thank you. All right, we will go on to our second case. Let me ask you on the first case. Did Mike Hatfield actually argue that? Mike Hatfield? No, he retired. I don't know. He's probably old guy.
Yeah, white hair, big handlebar mustache.
From Umatilla. Oh, Tavares.
Tavares.
I thought he was from Umatilla. He used to pride himself
Looked like he could have been on Dallas or something like that, with a big mustache like that.
That guy out in the audience is one of our new staff attorneys. That's Jodis Woody. He's Okay, all right. On to the next oral argument case here. Again, it's December 8, 2022. This is case number 21-3201, Dontavious Olajuwon Grimes versus the state of Florida. Counsel, if you're ready. So you want 5 minutes for rebuttal, or you want a different amount?
Yes, please. 5 minutes would be sufficient. Thank you.
That's fine.
May it please the court, good morning, Your Honors.
Good morning.
Brian Savy on behalf of the appellant in this case, Dontavious Grimes. First, I want to start by saying I submit that based upon the case presented against Mr. Grimes in both his trials, consisting largely of the heavily impeached testimony of a single ID witness, the materially inconsistent testimony of his felon friend, Mr. Lloyd, and with no physical evidence linking Mr. Grimes to the crime, the testimony of Kendrick Kitchens would likely produce an acquittal if he were permitted to testify at a second retrial. And I understand, I know we don't get there unless Mr. Kitchens' testimony is deemed to be credible. And I know that the trial court found to the contrary. But the state's argument that Mr. Kitchens was not credible, which again was largely adopted by the trial court in its order, almost verbatim, was not based upon competent substantial evidence. That's what I'm going to be getting into initially first as it relates to Mr. Kitchens' testimony.
Well, I mean, so if the post-conviction, well, let me ask, was the post-conviction judge the same as the one who tried the case?
It was not.
All right, so the post-conviction judge here is sitting there, and if he gets in his mind, I think this guy, Mr. Kitchen, just an absolute bald-faced liar, doesn't know anything about anything, but he's much more polite in his written order. Why is it that we get past that and say, okay, judge, you committed a reversible error, let's have a new trial?
I understand what the court's point is. If observing, I guess, the demeanor of the witness as the witness is testifying is definitely something that the court can factor in. I think that there's an indicia of reliability within his testimony, aside from any demeanor, whether the court found him to be not credible because of his demeanor or appearance.
Did the post-conviction judge say that they were both in the same pod at the jail?
Yes.
So I mean, they were accessible to each other leading up to Mr. Grimes' trial, and certainly Mr. Kitchen could have said, I don't know, what are you doing? Why are you on trial? I know you didn't do it. I saw who did it.
Right.
That would seem, if I was, just kind of spitballing here, if I was Mr. Grimes, that would certainly be something that I think would be a good tidbit of information to provide to his trial counsel, saying, hey, there's the guy.
And I understand that, and I think a lot of that was largely speculation as to what type of contact these two individuals had. Being in the same pod, I understand, I don't know that there was any evidence presented, and I don't believe there was.
But I mean, the post-conviction judge is there, somewhat suspicious or dubious about, after you're convicted and sentenced, now somehow you all are talking more in the pod, and now Mr. Kitchen is coming forth with, if credible evidence, would certainly be of interest to a jury.
And I understand that point, and as it relates to Mr. Kitchen's actual testimony, I believe the indicia of reliability, there's certain things he testified to that did not come out during the trials that I think gives it an indicia of reliability. Because if the theory is that they collaborated together in the same pod to try to come up with and concoct this version of the events that Mr. Kitchens was a witness in the case, I think that
Well,
there's
and
certain...
And then the post-conviction court might think, well, if they say, well, we didn't collaborate, maybe the post-conviction court thinks that that's somewhat of a dubious claim being made under oath by a guy convicted of first-degree murder and sitting in prison for life.
Understood. So as I understand the question is that,
Well, there's many times some of us who've been trial judges sit in these kind of hearings, and all of a sudden we hear people who have nothing, could be perceived to have nothing to lose as sitting in prison for life, come forward and make these statements of exoneration under oath that seem like they could have been readily provided to a jury.
and that's a good point. The readily provision, these facts that he testified to, Mr. Kitchens testified to, especially specifically about Ms. Torres, because I believe there was a connection to one of the witnesses and her boyfriend. There were certain facts that he testified to that none of this came out during the trial. So it would have been impossible for them to collaborate on these very specific facts that he testified to that Ms. Torres actually corroborated through her testimony, specifically that she was dating someone named James, that James did cut people's hair for a living, that James did sometimes stay with her at the Arlington Apartments with her. James was at the Arlington Apartments on the day of the homicide. Her apartment was 3 doors down from the entrance to the apartment complex. She smoked marijuana during the time period of the homicide.
Wasn't there a big problem with the timing that evening as
Yes.
far as the evidence presented during the trial and the times that these events occurred was very different from the timing that Mr. Kitchens provided in his testimony, correct?
That was a major point made by the state as an argument, obviously, and adopted by the trial court.
Did any of the witnesses at the trial corroborate or were consistent with Mr. Kitchens' timing of the events and how they occurred?
Not the specific time that he gave, and I think he gave an approximation of 4 p.m. And again, we're dealing with, I think it was July, when we're dealing with this time period of the homicide. I don't remember the exact date, I don't have it in front of me. I know it was in July. So we're dealing with a situation where the sun doesn't go down till much later, and at this point in time, the difference between when the actual homicide is supposed to have occurred, which they pinpoint as 5:49 p.m. by the call that comes in, the 911 call initially, the difference between 4 p.m. and 5:49 p.m. I think is negligible, and I think it would have been more suspicious if Mr.
There was like a 3 o'clock or a 3:30 timing somewhere in there as well, too, correct?
I don't recall seeing that. I recall him saying approximately 4. That was my recollection, and that's what I believe I cited in there. But I'll defer, obviously, to the record. If that was in there, I'm not going to dispute it. I believe he was estimating. Obviously, he indicated he was not wearing a watch. I think it's reasonable to believe that in his lifestyle that he admitted he was living at that time, he was kind of a going house-to-house transient drug dealer type. I believe he admitted that's what he was doing that day. He was very forthcoming with his testimony about his activities on that day. So we're dealing with a situation where he's just out in the street and doing what he's doing. He's not sitting there saying, okay, I got this appointment at 5:30 I need to go make, and he doesn't have like landmarks of time where he says, that are defining his day. I think that's the best way to put it. So I don't believe that is a huge problem, because I think it's more suspicious if he comes before the court and says, well, it was 5:35 p.m. when I made these observations. I think that's far more suspicious, because the time does come out during both trials as to when the 911 call comes in. That very definite time does come out. So I submit that was the major point that they were saying was conflicting with, other than obviously the identification of the perpetrator, that being a huge point. But as it relates to it, I don't believe I believe it's a negligible difference based on the circumstances surrounding it.
I mean, it looks like the post-conviction judge in his order that's now before us goes through several pages analysis as to why, in his view, your newly discovered witness, Mr. Kitchen, is perhaps less than credible. We leave it at
Sure.
that. How do we reverse, if we have to accept that these facts are supportable by the record that was heard and the credibility determinations made by the judge? I guess I'm struggling with how we reverse based upon that. In other words, the post-conviction judge didn't just say, well, I listened to this guy, I don't find him credible, have a nice day, motion denied.
Well, I believe that every single point they make can be discredited.
You
at the
think,
trial
so
court.
so that post-conviction judge got every single point wrong?
I submit that there is a competent answer, a counter answer that is supported by the competent evidence, substantial evidence in the case, as it relates to every single point they brought up to Mr. Kitchens, who I submit is far more credible than the witnesses that were put forth by the state. And obviously, I'm naturally going to say that.
You got to say that, don't you?
Right. But I can go down the points, that they're referenced in my brief, but I'll go down the
Well, I'm
points.
just saying that, obviously, that's something that has piqued my curiosity as to how the post-conviction judge has gone in pretty good detail about why it is that he does not believe Mr. Kitchen's testimony would matter at a retrial, and therefore he's inherently incredible, or how did he call it? Inherently what? Wholly unbelievable, I guess is what he said.
Right.
And we have to get past that and say, okay, I
Right.
know you've determined credibility of Mr. Kitchen, the sole basis for this motion is wholly unbelievable, but we're not going with that post-conviction judge. Time to give a new trial.
I think there's either a rational explanation to counter every single point made, or they're not based, or the finding is not based on the competent substantial evidence. And specifically, I'll go down. There's in its order, the court cites that Mr. Kitchen's first letter provided no details other than the conclusion that the defendants did not commit the crime. The court disregards the fact that the Cocoa Police Department, specifically Detective Bradshaw, recorded an interview after learning of the letter with Mr. Kitchen, and that Mr. Kitchen was not impeached at the evidentiary hearing with a single inconsistency from his interview with Detective Bradshaw. And I think that was a point brought up by appellee, is that, the first time that everybody's hearing about this identification of Mr. Dunham is at the hearing, which is not logical, and the state did not make that argument because they knew. They had done their own investigation into this by sending the agent out to go interview Mr. Kitchen.
Well, what wasn't one of the significant factors, at least what I gleaned from the order, is, oh, by the way, Mr. Kitchen in his own trial basically tried to convince a young lady by the name of Megan Connor to basically give a false alibi for him. And so if Mr. Kitchen would do that, what is it, anything about him that when he says anything should be credible in front of a judge on this post-conviction hearing?
And I understand the point. I think the
Pretty
court
significant
fails.
point, at least to me. So again,
Sure.
I'm tipping my hand about, you really need to convince me why, when the
Absolutely.
judge is saying these things in the order, that
The
somehow we
context-
get past all that.
Sure. The context of Ms. Connor's testimony, the court fails to mention that Ms. Connor never responded to the letters that Mr. Kitchen wrote to her, attempting to dissuade him of this belief that she was with him during the time of the homicide in his case. So if we're dealing with this, if she says to him, hey, listen, I wasn't there, stop bothering me with this, I'm not going to be a witness for you, and he's persisting, I mean, at that point in time, okay, yeah, he's trying to procure false testimony at that point in time, or at least I think there's a strong suggestion that he's trying to do that. I mean, he still could be right. I mean, he still could have been with her at the time, but regardless,
But the post-conviction judge here seemed to believe her.
right, that she wasn't with him, and that
she
he had
went
written
to
a
lie
letter.
for him at his trial.
Right. And I understand, and the point is that Mr. Kitchen was never given any opportunity to say, hey, listen, okay, I understand that you're saying you're not going to be my alibi witness, and I understand that, and I'm going to leave it alone. He was never given that opportunity. He wrote the letter saying, I believe you were with me during this time. Would you be a witness? As I'm sure it happens in a lot of cases. But he sends this letter, and we have a situation where she doesn't respond. She goes right to the police, turns him over, and says, look, he's trying to get me to be an alibi witness, and I wasn't. So at this point in time, I don't believe he's really trying to necessarily procure false testimony unless he's being provided an opportunity to know that she's saying, no, I don't agree with you. I don't believe I was with you on that day. So that would be my point to that question. I don't know if that answered it, but I'm attempting to. All right, so we're dealing with Mr. Kitchen's testimony. As I stated before, the court largely adopted verbatim the state's argument as its factual findings, and you can see that that's the case if you look.
When you say largely adopt, I mean, the state didn't prepare a proposed order that the judge signed.
No,
I mean, the judge listened to whatever and made.
It was a document. We did further argument where it's like almost like a memorandum of law, and it's almost verbatim. I think it's on the record on appeal, and I think I cited Volume 1, State's Closing Argument, 208 to 225 in the record on appeal. And the reason that I'm able to point this out, it says, in its order, the court cites that Kitchen's delay in reporting what he allegedly saw also defies logic and is unexplainable, given that during the same time period, the defendant had his own pending murder trial. There's obviously a mistake, a Scribner's error, because he wasn't the defendant in this particular case. But the state put that in their particular response, or state's closing argument. So that sentence came verbatim from the state's closing argument.
There's no real dispute that Mr. Kitchen and Mr. Grimes know each other, right?
I don't think there's any dispute that they were housed.
Before the murders took place. I mean, I forget who was convicted. I mean, they knew each other. This isn't just somebody who was in the jail that says, boy, I remember that, and you weren't the guy. I don't know who you are, but Mr. Grimes, you weren't the guy that I saw do the killing, if that's the killing we're talking about.
I don't recall any evidence being presented that they knew each other prior to the homicide. That's not my recollection. I don't believe that came out during Mr. Kitchen's testimony or any testimony presented by the state to say that, hey, look, these guys are best friends leading up to this.
Was Mr. Kitchen's testimony giving at least the inference that he believed that a Mr. Dunham was the one who was the shooter?
I'm sorry, can you repeat the question? I'm sorry.
The post-conviction judge seemed to think that Mr. Kitchen was pointing the finger at a Mr. Dunham as the one who was the likely shooter here. And the post-conviction judge obviously thought that was not too believable, considering Mr. Dunham and the victim were friends, and Mr. Dunham got a tattoo of the victim on it.
Right, and that was in the record.
Right.
I submit that they were friends supposedly for 2 years. It's not like these guys were lifelong friends. I think that's the evidence that came out. More importantly, I thought it was highly suspicious that Mr. Dunham, when he testified, could not recall where he was when his close friend was supposedly murdered. I think that's a highly suspicious circumstance. If he finds out, okay, that's something that a life event that most people, if they have a good friend that's killed, they're going to say, okay, I remember where I was when I found out at least, and going to be able to backtrack and say, oh, I know where I was probably from that point in time. I don't think that's an unreasonable leap. And he got this tattoo. I think he got the tattoo in prison, if I recall correctly. Crudely made tattoo. So it's not like he went out and said, I'm going to go spend some money and honor this gentleman right off the bat. It was years later when he goes to prison, I'm going to get a crude prison tattoo. So I think that answered that. I'd like to reserve the rest of my time for rebuttal if I might.
Sure.
Thank you.
Mm-hmm.
Good morning, Your Honors.
Good morning.
May it please the Court, my name's Dan Caldwell. I'm with the Attorney General's Office here on behalf of the State of Florida. Your Honors, it's the State's position that the trial court's finding of fact, specifically that Mr. Kitchen was not a credible witness, is supported by ample, competent, and substantial evidence. First, I think it's very telling that the trial court found that it defied logic that Mr. Kitchen waited so long to come forward with his letter. They were in the same jail pod together. This offense had happened long before, and it's only 2 weeks after the conviction that Mr. Kitchen says, Mr. Grimes, you know what, I'm going to write a letter. You're not the guy who did this. The reason this is important is because Mr. Kitchen had a reason to come forward with this. We know from the evidentiary hearing that he asked Ms. Connor to testify and give him an alibi. Now, there's been some characterization that they were simply disagreeing whether or not they were together at the time of his own homicide. Ms. Connor didn't testify to that. She said specifically he asked her to provide an alibi. He asked her to go to his attorney, told her what to say and how to say it. She even kept the correspondence, and the state did try to introduce that into evidence. Unfortunately, it was excluded based on a hearsay objection. So we don't know specifically what was written in these letters, but we do have Ms. Connor's testimony that Mr. Kitchen tried to get her to give him a false alibi. So we know he's facing this homicide trial. He tries to get a false alibi. That doesn't work. It absolutely defies logic that he would not come forward to the police and say, you know, the murder that happened over at 131 Aurora, I saw it, I know who the killer is. Substantial assistance is how police work operates. The police find somebody who might be less culpable or is less of a bad guy than somebody else, and they say, okay, you testify for us, and maybe the state will cut you a break. That's how CIs are made. in drug cases. So he had every reason, Mr. Kitchen had every reason to come forward with this information, but he never did. So that definitely cuts against his credibility. The trial court was also correct when it found that there was very little detail. It's a general letter that says, okay, I was there, the individuals who were convicted are not the ones who did the shooting. It's not until we get to the evidentiary hearing, and evidently there is some reference in the record to an interview with Detective Bradshaw, but there's very little questioning about what actually occurred there. But that's when we hear Mr. Kitchen's story, that he was at the apartments around 3 o'clock. He got there at noon. He smoked a little, hung out, got his hair cut by James Hooks at 3 o'clock in Mr. Hooks and Ms. Torres's apartment. She asked him to go procure some marijuana, at which point he ends up at 131 Aurora, meets the victim, they smoke a little, talk. Later on, Mr. Kitchen returns to Arlington Apartments. I can't recall if he's back in Ms. Torres's apartment at this point, but he sets up a drug sale at 4. Now, the argument that he didn't know what time it was because he didn't have a watch and it's summer, well, somehow or another, he did set up this drug sale with Jimbo at 4 o'clock, which is what allegedly put him out at the murder scene. Even the old flip cell phones had a clock on them when he opened them, so he must have had some idea of the time. And the time is very important because the time is corroborated by all of the other witnesses and the evidence. Ms. Torres, first of all, said she did not even get home until 5:30 because she got off work at 5:15. She got home at 5:30, let her dog out, heard the shots, ran inside, got her kids. Mr. Molosky, who I believe is one of the few witnesses who did not have any convictions, he testified it was between 5:30 and 6. He was watching the news. He heard shots. He called 911. He couldn't recall if that was before or after he stepped out into his yard, but he was told
Was there
yes.
any evidence presented at the 3850 hearing that Mr. Kitchen and Mr. Grimes actually had any contact in the pod pre-Grimes's trial?
No evidence that that occurred before the trial, no, Your Honor. The only testimony, there was a question asked, I believe, in cross-examination by the state where either Mr. Kitchen or Mr. Grimes had made a phone call to the other's family to ensure that they got a care package, but it's unclear.
Was there evidence that Mr. Grimes and Mr. Kitchen knew each other before they were both put in the county jail?
No, Your Honor, there was no evidence to that. Again, that didn't come up at the trial at all, and there was no evidence as to whether, there's nothing presented at the evidentiary hearing to that I can point the court to. But they were both in the same jail pod. 300, I believe is what it was, which is where one goes for violent offenses. And Mr. Grimes' offense occurred in 2014. I don't know when Mr. Kitchen's trial was. We only know he did face a homicide trial, and at the time of the hearing, he was facing a life sentence. So it would be we don't even know if the life sentence was for that homicide trial.
So how would Mr. Kitchen know to tell Mr. Grimes that, oh, by the way, you're not the guy who did the killing for which you're being charged with, if they hadn't ever met each other before 13 or 14 days after Grimes was convicted?
I can't tell you that there's evidence that states that, Your Honor. However, if they're both in the same jail pod, and we do know that there was some contact at some point before the evidentiary hearing, because as I mentioned, I can't remember whether it was Mr. Grimes or Mr. Kitchen, but on cross-examination by the state, Mr. Kitchen was asked why he would be contacting Mr. Grimes' family in regard to making sure he got his care packages, or vice versa. I might have those mixed up, but there was some type of contact, at least between Mr. Grimes and Mr. Kitchen and their family members in regards to the care package. And it is reasonable to assume people in jail are going to talk, the inmates are together. It's not unreasonable for the trial court to have concluded that it was imminently possible that...
Possibilities, shouldn't that go back to a jury to let them decide which of the several possibilities are actually real?
Not in this case, Your Honor, because the issue isn't whether or not Mr. Grimes and Mr. Kitchen had contact. It's whether or not the trial court's finding about Mr. Kitchen's credibility is supported by competent, substantial evidence. And Mr. Kitchen's testimony itself does not...
A lot of it seems to be these guys were together in the same pod, therefore they cooked it all up, which may indeed be the fact. It may not be the fact, but what's the evidence to support that?
The evidence to support it is that Mr. Kitchen had only a very general knowledge. His own testimony, while not directly impeached, it was contrary to the testimony of all of the other witnesses. The timing is important because, again, it's impossible for Mr. Kitchen to have been in Ms. Torres's apartment at 3 o'clock because she did not get off work until 5:15 and did not arrive in her apartment until 5:30.
James didn't have a key.
She testified James did not have a key. They were not together at that point, living together, and while Mr. Hooks did arrive at the apartments, he didn't arrive until after the shooting, and he didn't have a key. So there's no way, first of all, that Mr. Kitchen could have been in that apartment. Ms. Torres also pointed out she does not know who Kendrick Kitchen is. He claims that he knows her. She says she did not. She did admit that she smoked marijuana back then, but she procured it herself. So that timing is very important. Also, the timing of the shooting lines up with the 911 call and with the reporting of the first officer. Officer Vieira Gonzalez testified that the first call went out. The call went out at 5:49. He arrived on scene with another officer at 5:57. Mr. Walker, the only actual eyewitness to the actual shooting, testified that after the shooting, he got in his 99 Grand Marquis, drove away, first went into the Arlington apartments, backed in, stayed there for a moment, and then he and Mr. Lloyd went across the street. Video evidence from the Arlington apartments around 6 p.m. Around 6 p.m. showed that Grand Marquis, which Mr. Walker identified, and he was actually standing outside of it, and he identified himself. So the timing all lines up with Mr. Walker's testimony. It doesn't line up with Mr. Kitchen's testimony. What's also important is what Mr. Kitchen did not see. First of all, he did not see the actual shooting. He had his back to the crime. He was engaged in a crack sale, as I recall, with Jimbo, I believe the gentleman's name was, who was driving a black Nissan Pathfinder. And he was alerted to the sound of opening doors. He turned, saw two black males walking with black weapons.
So if he didn't see him, if he didn't see the shooting, how does he know Mr. Grimes didn't do it?
Well, I'm sorry, Your Honor, would you restate that?
If he didn't, all right, so if Mr. Kitchen didn't see who did the shooting, then he didn't know if Mr. Dunham did, and he wouldn't have known whether Mr. Grimes perhaps actually did do it. I mean, it'd be one thing to say, I was there, it wasn't that guy, it was this other guy over there. There was that Ray guy out there who did the shooting.
Correct, Your Honor. He's not a direct witness. The only witness who saw the actual shooting is Mr. Walker. And Mr. Walker and Mr. Lloyd both testified to seeing a chrome pistol. Mr. Kitchen did not testify to seeing that. Mr. Kitchen was inconsistent in how he left the scene. First, on direct examination, he said he's heard that first shot and he walked away quickly. However, on cross-examination, he said he ran. I believe he said he was worried about getting hit himself because he said something to the effect of bullets don't have eyes. Also, he never testified to seeing Mr. Walker's vehicle, a 99 Grand Marquis, in the driveway of the victim's house. And both Mr. Walker and Mr. Lloyd testified that they were present in that vehicle and then during the shooting, and then they left. Granted, Mr. Lloyd did not see very much. He saw the chrome pistol, and then as soon as he heard shots, he went down on the floor. But Mr. Kitchen's testimony is completely at odds with all of the other witnesses. There's also physical evidence that further corroborates Mr. Walker's testimony, but that's actually beside the point when we're talking about the credibility. The point was, what was the trial court looking at to determine whether or not Mr. Kitchen was credible? Mr. Kitchen said it happened, that he was at the apartments getting his hair cut at 3. Ms. Torres said he couldn't have been because I wasn't there and I don't know him. Mr. Kitchen said he did a drug sale at 4 and that's when this shooting happened, but that doesn't line up because we know Mr. Walker, after leaving the scene, his vehicle was filmed at about 6 in the evening. We know the 911 call went out at about 5:57. We know Officer Vieira Gonzalez reported it around 5:55, got to the scene. We have the witnesses who heard the shots between 5:30 and 6. Mr. Kitchen testified to none of that. Mr. Kitchen did not testify to seeing the same chrome-plated pistol that 2 witnesses testified to. And again, to return to the fact that he did not come forward sooner, and when he had every reason to do so, I believe is definitely relevant. Therefore, Your Honors, based on the ample, competent, substantial evidence presented below in the evidentiary hearing and at trial, the state would ask this court to affirm the judgment below in all respects.
Any questions? All right, thank you, counsel.
Thank you.
All right, counsel, looks like you have 4:22 on the clock on rebuttal.
Thank you. All right. Counsel mentions that Mr. Kitchens only had general knowledge, and I don't believe that is an accurate recitation of what actually was presented on the record. And I've cited in my brief very specific facts that Mr. Kitchen testified to. I don't want to waste my time going through all of them, but I count at least 17 distinct facts that he testified to that were not just evincing a general knowledge. Furthermore, counsel argues
Did not see the shooting, is that correct?
he's saying he did not see the actual shooting itself, and that is correct. That is what he testified to, but I think the logical inference from his testimony is who else would it have been based on what he saw? And he saw people roll up in a vehicle, get out, and approach. At that point in time, he saw the guns. That's when he decided, I'm not sticking around. As I think the comment was, bullets have eyes, I think was the comment. It's creative. Regardless, counsel also argues that, about the delay in reporting, Mr. Kitchen's delay in reporting, and it defies logic, is unexplainable. And I submit that it's far more logical than Mr. Walker's explanation for why he changed his story after 48 denials of being a witness to this, to identifying Mr. Grimes as the perpetrator. We have a situation where supposedly somebody else other than Mr. Grimes makes an attempt on Mr. Walker's life. And all of a sudden he decides, you know what, I'm emboldened. I'm now going to identify Mr. Grimes, who's not the person who made the attempt in my life, as the killer. I think it's also important to note he makes an identification of the person he believes to be the killer to law enforcement. And what does he do? He then backs off of that and says, no, it wasn't this guy named Bop. It was, I know who it was, but it wasn't Bop, even though I identified him. I think that goes towards his credibility. Counsel raised substantial assistance as far as the logic of Mr. Kitchens coming forward and when he provided this information. I don't think it's a logical argument, and the reasoning is, if Mr. Kitchens is to provide information to the police that they arrested the wrong guy, what type of assistance is he expecting to get out of that? That doesn't make any sense, because he's not going to. Certainly the police believe they have the right guy, and they're not all of a sudden, based on a guy charged with murder who's sitting in the county jail, based on his word, going to say, you know what, we're going to arrest this other guy you say
Had
it is.
Mr. Kitchen been convicted of murder at the time he wrote his letter on behalf of Mr. Grimes?
I don't believe so, and I can't recall if the record was absolutely clear on that, but I believe his trial was pending, is what is the evidence that came out. So I think that
They would
answers.
really think that wasn't very assisting if a guy who's being charged with murder, not convicted yet, is now saying, oh, by the way, you convicted the wrong guy.
Right.
Aren't you happy I'm helping you, police?
Right, and what did he think he was going to get out of this? The state never established any motive, and I believe counsel argues something about this care package. That was not in evidence, and there was a question based on a lack of foundation. There was no predicate to it, and I probably should have objected to it, but he answered no, and it was done. I may have objected to it, I don't recall. But I do recall that question being asked with no factual basis. He denied it. There was absolutely no evidence of any connection, any reward, any motive for Mr. Kitchen to suddenly come up with this, concoct this story and to help Mr. Grimes, other than the fact that he actually was there as a witness and observing what had occurred. And maybe he's in the same pod, but as far as when he's finding this out, there's no evidence as to when he found out that they'd actually had a discussion about, hey, this is the facts of my case. I'm charged with a homicide that happened on 131 Aurora. And there was no evidence of that. There's also counsel raises the time. And I understand Mr. Kitchens estimates a time, and it's different than what what I think is credible evidence, establishes at 5:49.
He misses out on some of the other events, too. I mean, getting the haircut in the apartment and doing a drug deal for Ms. Torres or whatever it is. I mean, there's a lot of things that don't quite add up. It's not just, it was 5 o'clock, he thought it was 4 o'clock. I mean, there's events that he says happened that everybody else says didn't happen.
Well, the only other person that says it didn't happen was Ms. Torres, and I think
We're not dealing with people who are necessarily going to get the Citizen of the Year award. They all have blemished records, shall we say.
Right. She's a convicted felon, but regardless, she testified, and this was kind of glossed over, and I'll make this final point. She testified that she didn't actually testify in the trials. She testified at the evidentiary hearing that she didn't recall actually testifying at the trials. So she was wholly incredible, and that's basically the argument as it relates to that, and I hope that answers the question.
All right, thank you, Counselor.
Thank you, Your Honors.
All righty. We'll stand adjourned. Have a good day.